Good morning. My name is Hallie Zobel. I'm an attorney here at CPLS in Orlando, Florida. I've practiced law 35 years, and I want to give you our telephone number to give us a call if you have a legal need. We can be reached at 877-647-7887. Today we're going to talk about your house. I'm an estate planning, probate, and guardianship attorney, and I get a lot of calls about your house. And most people in Central Florida own homes, and your home has increased in value these last several years. You may not even realize the value that your home brings. And these calls I get are people wanting to call up and add a name to the deed. I say, wait a minute, don't do that. We got to have a conversation, and I need to give you legal advice of the complexities that act can cause and trouble. If you don't mind, we're going to take a few minutes and go through the different types of deeds on a home. When you purchased your home, you homeowners out there, you most likely received a warranty deed that the seller signed it over to you. And it's nothing more than a legal real estate document that protects you, the buyer, against any future claims to title on that property. No one wants to own a house and 4 years later someone come out and say, I'm the owner of the house. That's my house. And then there's a problem with the title. But warranty deed does just that. It warranties to the buyer that there's no future claims that can come. You have proper title to the property. How about a quitclaim deed? You listeners, if you've had a divorce, you most likely may have initiated or executed a quitclaim deed, or your spouse did to you. That's a legal document where the owner of a piece of real property transfers any interest they own to the recipient of the deed, and the owner terminates any rights they have and claim to the property. The difference in this quitclaim deed is no warranty. You got to be real careful, folks, and make sure this is the type deed that you want. It's a quick way to transfer property. That's why people like it, and it's most often occurs between family members. Let's talk about a married couple. In Florida, we follow Old England common law. Still, as you know, anyone who studied history and U.S. history knows our law comes from Old England. Now, tenancy by the entirety, that's just a fancy term when two spouses own property, a married couple, and each one is considered to own the whole property, not just half of it, because they're married. This is very protective, so a creditor of one of the spouses cannot reach that house and force a sale. Not every state has that, but Florida does. Let's talk about a joint tenant with right of survivorship. I bet you've heard of that term on a bank account. Well, on a deed, you can have the same thing, joint tenants. Rights of survivorship just means if one of you passes away, the other owns the property. Nice thing about that is no one has to go to court, no one has to see the judge, and it passes by operation of law. One other type of deed I'd like to talk to you about, it's tenancy in common. If two individuals own a property entitled as tenants in common, one of them dies, then that half goes through the owner's estate. It doesn't pass over to the other owner. It passes through the individual's estate, and that can be complicated because I've seen time and time again people come into my office and believe they're the owner of the property because their brother died and they owned the property with the brother, but they owned it as tenants in common. Deeds are very serious, and you want to make sure that you get it right on your deed. Now, calling up the attorney for deed advice is one of the best things you can do. A lot of times I'll get a call and they want a quick answer, and I don't have a quick answer. Maybe they purchased the deed from Office Depot. I don't want to hear that. The deed might not be properly drafted. They want to know if they can add their adult daughter on a deed to avoid probate. Maybe the gentleman's getting up in years, he's retired, and he's heard that adding the adult daughter's name can go ahead and be protective. And I say, protective of who? Of what? And sometimes people call in, y'all, and they don't even know what they want to protect from. And I get the answer, ooh, the government taking the house or they? And this is where I said, who's they? They, is they going to take the house? So, what are some reasons why that gentleman shouldn't add his adult daughter on his house deed? Well, first of all, he can screw up his homestead and possibly lose a homestead privilege, and we don't want to do that. We attorneys look at things differently. We look at it through multiple lenses. We want to make sure and look to see all the positive but all the negative things that can happen by adding a name on a deed. And you may think it's just innocuous and it just will serve the purpose, but it can really be problematic. Did you know that the elderly gentleman who adds his adult daughter on his house deed has just made a gift? He has to file a gift tax return. And you say, no way. And I say, well, he will need to go see a CPA and advise and tell him, hey, I gifted my house, because adding a name on the house, isn't that really just a gift to the adult daughter? Certainly the house has value. Doesn't mean that he'll necessarily pay a tax, any type of gift tax, but he does have to report it to the IRS. Here's another reason not to do that. Did you know it could mess up the child's tax and cause him or her, the adult daughter in this example, to have to pay capital gains taxes when she goes to sell the house down the road? If the house passes through probate, and I'm getting out in the weeds here now, and I want you to stick with me, there's no step up in basis. That means that the children take the parents that they inherit from, or grandparents, they take a step up in basis, and the government won't go after them for capital gains tax. That's a real benefit. Not so if you add the child's name on the deed. I bet you didn't think of this. It could mess up public benefits planning if that elderly gentleman has to go in a nursing home. He's considered giving a gift to his daughter on the house, and that could mess up his benefits. And so that's a whole conversation for another day, but this is another reason we advise against that. People want to do this because they want to avoid probate. I hear this over and over and over, avoiding probate. You can avoid probate in a variety of different ways, and that's a conversation for another day, but be very careful when you're taking names off of deeds. I advise you to go to your attorney and see what's the best way to handle that. I thank you for your time this morning. Remember to give us a call at CPLS at 877-647-7887. My email and my name again is Hallie Zobel, and email is hzobel@cplspa.com. Thank you again.